You know, how we define our words can have a surprisingly big impact. Sometimes those definitions can even collide with something as significant as who gets to stay in the country.
It sounds like a stretch, maybe, but it's a very real tension playing out right now. Definitions, especially around sensitive topics, they can become powerful tools.
Exactly. And today we're diving deep into a stack of sources, articles, reports, legal analyses that explore a really complex intersection. We're talking about the debate around defining anti-Semitism, the boundaries of free speech, and how U.S. immigration law gets tangled up in all this, particularly for, well, non-citizens who are critical of Israel.
Right. Our mission here is basically to unpack this material. We want to understand, where this controversy began, how a specific redefinition has been used.
And what recent legal battles tell us, right? About that fundamental tension between, say, government authority and individual rights.
Precisely. Let's get into it.
Okay, so at the center of a lot of this discussion is a specific definition.
That's right. What's often referred to as the working definition of anti-Semitism. This was published by the European Union Monitoring Center, the EUMC, way back in 2005.
And it included something pretty well known now, the 3Ds test.
Yeah, created by Nutt and Sharansky. The idea was to offer criteria, sort of guidelines, for identifying when criticism of Israel might cross the line into anti-Semitism.
The 3Ds, remind us.
Sure, it's delegitimizing Israel's right to exist, demonizing Israel or Israelis using, classic anti-Semitic tropes, or applying a double standard to Israel that you wouldn't apply to other countries.
Okay. But what's really interesting, looking at the history in these sources, is that this EUMC definition, it wasn't really set up as a formal legal thing at first.
No, not at all. It was explicitly called a practical guide.
A guide.
And what's notable is the EUMC itself never formally adopted it. Actually, it was later removed from their website.
Removed?
Yeah, and a spokesperson clarified they didn't even see it as a, quote, valid definition.
Wow. So the body that published it basically walked it back. Still, we see the U.S. State Department using it in report, I think around 2008.
They did, yes. But, and this is crucial, they included a big caveat right there in that report.
Okay, what was the caveat?
They stated that some ways other countries were approaching this could violate the U.S. First Amendment if applied here. And the department explicitly said they did not endorse measures that would prohibit constitutionally protected conduct, like free speech.
So they used it, but with a clear warning label attached, basically.
You could say that, yet despite that initial caution, there's been this, persistent and pretty significant push to get this specific definition widely adopted.
And often in ways that seem to bump right up against that First Amendment warning.
Absolutely. Initially, this push really targeted U.S. campuses between about 2008 and 2014.
What happened there?
Pro-Israel groups filed federal complaints. They used this definition to argue that Palestine advocacy on campus created an anti-Semitic environment.
But those didn't get very far initially.
No, notably, those early complaints were often dismissed. Didn't gain much legal traction right away in that specific context.
Okay, so the strategy changed.
Seems like it. Around 2015, things shifted. The definition started gaining more acceptance, especially in Europe, but also with some U.S. student governments picking it up.
And then came a really significant turning point with the Trump administration.
That's right. That's when we see the, controversial adoption of this definition through a 2019 executive order.
And that had a real effect.
Oh, yeah. It led to a clear uptick in federal complaints and investigations targeting campus Palestine advocacy, all based on this definition.
And the actions being cited in these complaints, they weren't always like physical threats or harassment.
No, often not. Our sources mention complaints citing activities like screening a documentary called Occupation 101.
Just showing a film.
Or students wearing T-shirts with slogans like, "You see Intifada." This led to actual cases and investigations against places like the University of California campuses and Rutgers.
And this push wasn't just about universities, was it?
No, it spread. It went to state and local levels.
Right.
States like Texas, Florida, South Carolina adopted the definition. And there were also documented lobbying efforts aimed at the big social media companies like Facebook and Twitter.
Trying to get them to use it.
Exactly. Urging them to use this definition to label criticism of Israel as hate speech. Basically trying to police online discussion using this framework.
So it looks like a pretty coordinated effort trying to embed this definition across society, even in private company rules.
That's certainly how the actions described in the sources come across. But it's important to say this campaign has faced really significant resistance.
From who?
from advocates for Palestinian freedom, lots of academics, civil liberties groups across North America, Europe, and even in Palestine and Israel. They've pushed back hard.
And has that pushback worked sometimes?
Yes, absolutely. The sources highlight instances where efforts to adopt the definition were defeated. Student governments at places like CUNY, Michigan State, Foothill College, Santa Clara University, they rejected it. And academic institutions, too, like University College London, they resisted adopting it.
There was also that Oxford University report you mentioned earlier that raised some questions.
Yeah, that Oxford report was pretty revealing. It suggested that the leadership of the IHRA, the International Holocaust Remembrance Alliance, which is often linked to promoting this definition. Well, the report suggested they might have knowingly misled the public about how widely the definition was actually adopted within the EU.
Misled how?
Critically, the report claimed the IHRA leadership misrepresented a decision to essentially smuggle in examples related to Israel, examples that member states had initially objected to and excluded.
So states didn't want the Israel examples, but they got put in anyway.
According to that report, yes, with the intention, it suggests, of using the definition specifically to shield Israel from criticism.
Wow, okay. That detail really changes how you might view the motivation behind pushing this definition, doesn't it?
It certainly adds another layer. Suggests the goal wasn't just clarifying anti-Semitism generally, but maybe specifically folding criticisms of Israel under that umbrella, even if members didn't initially agree.
It makes the whole thing way more complex.
Definitely. And this whole ongoing debate about where the line is, between legitimate criticism of a state and actual anti-Semitism, it led to other frameworks, like the Jerusalem Declaration.
Right, I've heard of that.
It aimed to explicitly distinguish between anti-Semitism and anti-Zionism, though it also got criticized itself for potentially still policing Palestinian speech in some ways.
So what's really striking here is how this definition started as a guide, publisher walked it back, faced pushback about its intent, has still been used as a justification to, target people and organizations.
That's the critical takeaway from a lot of these sources. The definition moved from being a discussion tool to, a tool for action aimed at silencing or penalizing certain views or activities.
Can you give us some specific examples from the sources? Who's been targeted?
Sure. We see cases like Ahmad Daraldik, a student leader at Florida State University. He faced this whole campaign to get him removed from student office.
Why?
Based on social media posts he made as a child criticizing Israel's military occupation. Pro-Israel students apparently used the IHRA definition to argue these old posts were anti-Semitic.
As a child.
Wow.
And it wasn't just student politics.
No, not at all. The acclaimed Irish author Sally Rooney, she was accused of anti-Semitism.
For what? Her writing?
No, simply for declining to sell translation rights for her book to a publishing house that was tied to the Israeli government.
Just for deciding who publishes her book.
Seems so. And then there's the whole Ben & Jerry's thing, widely reported. Accused of corporate anti-Semitism by a right-wing group after they decided to stop selling ice cream in Israeli settlements in the occupied territories.
Even major human rights organizations were reportedly in the crosshairs.
According to one source, yeah. The Trump State Department apparently explored designating groups like Amnesty International, Human Rights Watch, Oxfam
as anti-Semitic. These big international groups.
That was the idea being explored, based on their criticism of Israel's actions. Now, that plan reportedly didn't happen, but the fact it was even on the table shows how aggressively this definition was potentially going to be used.
Okay, this brings us to a really crucial, maybe even unsettling intersection discussed in the sources. How does this campaign, this push to institutionalize a specific definition of anti-Semitism, connect with U.S. immigration law, and specifically with non-citizens?
Yeah, this is where the stakes get incredibly high for individuals. U.S. immigration law gives the federal government just remarkably broad authority over who can enter the country.
And critically, who gets to stay here, right?
Yeah.
Even if they're lawful permanent residents, green card holders.
That's the fundamental legal reality. Even if you have a green card, you don't have the same absolute right to remain as a U.S. citizen.
So the First Amendment applies to non-citizens here, but there are limits when it comes to immigration.
Exactly. While the First Amendment generally applies to non-citizens physically present in the U.S., the sources show this historical pattern where the government has used immigration law as a tool to control or suppress what it sees as political dissent.
And this isn't new. This tactic has deep roots.
Oh, absolutely. The sources point back to things like the Red Scare after World War I. You had immigrants rounded up in the Palmer raids, deported based on political affiliations, perceived radicalism, often with very little due process.
And legislation followed.
A key piece was the Immigration and Nationality Act of 1952.
Also known as the McCarran-Walter Act.
That's the one. It has a, quote, storied past, as the sources describe it, for allowing the monitoring and removal of immigrants based on their ideology, particularly targeting communists during the Cold War. It basically formalized the government's power to use immigration status against perceived political threats.
So fast forward to today. Can someone with a green card actually be deported just for holding a controversial opinion? Like, say, criticizing U.S. foreign policy?
Generally, no. Just holding an opinion, even a controversial one, isn't usually grounds for deporting a green card holder, but the law does allow removal for specific things.
Like what?
Advocating the violent overthrow of the government, certain activities linked to terrorism, like providing material support, or immigration fraud lying on your applications, things like that.
Are there specific parts of the law that seem particularly relevant to political speech, even if it's not violent?
Yes. It's complex, but sources mention provisions like INA Section 237A4. That relates to engaging in terrorist activities, which could potentially include speech used for fundraising or recruiting for banned groups.
Yeah.
But there's another provision, maybe even more concerning, from that same 1952 INA. It allows for removing a non-citizen if the Secretary of State believes their presence or activities would have potentially serious adverse foreign policy consequences for the United States.
Wow. Potentially serious adverse foreign policy consequences. Sounds incredibly broad. Very open to interpretation.
It is, and the sources show this specific provision, this exact language, has been invoked in recent cases. Secretary of State Marco Rubio notably cited this 1952 INA provision as a basis for action in one of the key cases we need to talk about.
And this tension, this conflict between broad government immigration power and the free speech rights of non-citizens, it's not just theoretical. The courts have grappled with this for a long time.
Decades. Cases like Harisietz v. Shaughnessy back in 52 showed just how much leeway courts historically gave the government. They upheld deportation for just past affiliation with a group the government didn't like, even without proof of current activity.
But things evolved.
A bit. Later cases, like Kleindienst v. Mandel, introduced a requirement. The government needed a facially legitimate and bona fide reason for excluding non-citizens. It provided a small basis for courts to review. And the Reno v. AADC case, the Los Angeles 8 case, showed that while challenging government immigration priorities is tough, removing non-citizens based purely on their political speech still required the government to show a rational basis. These cases really map out this long legal tightrope walk.
Which brings us right to a central case study highlighted in this material. Mahmoud Khalil.
Right. Mahmoud Khalil, he's a student at Columbia University, and he holds a green card. His case really blew up after he got involved in anti-Israel protests on campus.
And it involved an arrest, right?
Yes. He was arrested back in March 2025 at his university housing in New York. But what really drew a lot of attention and criticism was what happened next, his detention and transfer.
He wasn't kept in New York.
No. He was arrested in New York, but then transported to a detention center way down in Louisiana.
Louisiana? Why?
Well, this tactic, moving detainees arrested in one state to facilities really far away, often in the South, like Louisiana or Texas, it's described in these sources as an increasingly common ICE tactic.
Is there a name for it?
The immigration attorneys sometimes call it late-night hopscotch.
Late-night hopscotch. What's the alleged strategy behind that?
The accusation is that it's deliberate. It's meant to isolate detainees, put them hundreds, maybe thousands of miles away.
Makes it harder to fight their case.
Significantly harder, yeah. Harder to access their lawyers, connect with family and support networks, gather evidence. It can really hinder their ability to mount a legal defense to stay in the U.S.
So why was Khalil actually targeted for removal? What was the government's official reason?
Secretary of State Marco Rubio issued a specific memorandum. He asserted that Khalil's continued presence in the U.S. compromises a compelling foreign policy interest.
And that's where he used that old law.
Exactly. That's where he invoked that broad 1952 INA provision. Rubio also publicly accused Khalil of participating in what he called antisemitic protests that created a hostile environment.
Were there any other accusations like the fraud thing you mentioned?
Yes. Department of Homeland Security lawyers also alleged Khalil had lied on his visa applications, claimed he didn't disclose some previous work history.
Okay.
But the sources really emphasize that the main legal justification for the removal proceedings and for keeping him detained seems rooted in those foreign policy grounds cited by the Secretary of State, linked directly to his political activities and the definition of anti-Semitism being applied.
How did Khalil and his lawyers push back?
They argued forcefully, said the government's actions were an attempt to erode his constitutional free speech rights, basically trying to stifle lawful dissent against Israeli government policies.
And this went to court. A federal judge recently made a pretty big ruling.
Huge ruling. On June 11, 2025, U.S. District Judge Michael Farbiarz issued a preliminary injunction in Khalil's case.
What did the injunction do exactly?
Judge Farbiarz granted it, blocking Khalil's detention and removal, specifically based on those foreign policy grounds that Secretary Rubio had invoked.
So a direct hit on the government's main argument that his speech was a foreign policy problem.
It really was. The judge's ruling explicitly indicated that the 1952 INA provision, the one allowing removal on foreign policy grounds, appeared unconstitutional as applied here, because it infringed on free speech rights.
Did the judge say anything about the impact on Khalil himself?
Yes, very clearly. Judge Farbiarz stated Khalil was suffering irreparable harm, damage to his career, reputation, and that his speech was being chilled by what the government was doing.
And he thought Khalil would win.
Significantly, the judge also indicated he expected Khalil to ultimately win the case on its merits. That's a powerful statement from the court at this stage.
It suggests the judge saw real legal problems with the government's case.
It does. The judge also specifically noted that Khalil's detention almost surely flows from the charge based on the Secretary of State's foreign policy determination, not so much the visa application claims, reinforcing that the speech issue was really central.
So the ruling was seen as a big win for civil liberties.
Definitely described that way. A huge win for the Constitution, for the rights of non-citizens. But it's important to add, as the sources do, the ruling was temporarily paused.
To allow an appeal.
Right, to give the government time to file an appeal. But that initial legal blow to using that specific foreign policy provision against speech was really substantial.
In Khalil's case, it doesn't sound like it was totally unique based on the sources.
No. The material points to other similar cases, where political speech seems to have been a key factor in immigration enforcement actions.
Like who?
There's Ramesa Osterk, another student, this time at Tufts University. She was arrested by plainclothes ICE agents, also transported to Louisiana. Her lawyer filed an emergency petition.
What was notable there?
What's interesting in her case, according to reports, is that an internal State Department memo apparently found no link between her and anti-Semitism or terrorism, despite some public statements suggesting otherwise.
Yeah.
And Dr. Badar Khan-Suri from Georgetown University is another individual mentioned. His case also reportedly involved targeting based on what's described as protected speech.
And these individual cases, they seem to fit into a wider picture, right? The Trump administration's focus on universities regarding issues like anti-Semitism and political dissent.
Absolutely. The sources connect these dots. They mention related actions, like the Department of Education opening investigations into dozens of colleges for alleged anti-Semitism.
There were funding threats, too.
Yeah, threats of significant funding cuts, like the nearly $400 million potentially cut from Columbia, and broader pressures on universities like Harvard about, quote, ideological diversity, which sometimes led to legal challenges cutting across typical political lines.
So these cases involving non-citizens aren't just isolated incidents. They seem to be part of a larger pattern. Pressure on individuals, on institutions perceived as critical of certain policies.
That's the picture painted by the sources, yeah. The attempts to apply a specific definition of anti-Semitism, combined with the government's use of its authority over non-citizens, they appear pretty intertwined within these broader efforts.
Okay, so pulling all this together, what does this deep dive really tell us?
Well, it highlights this ongoing, really complex battle over how anti-Semitism is defined, and crucially, how attempts to institutionalize a particular and contested definition can intersect with the immense power the U.S. government has over non-citizens, especially in immigration law and foreign policy.
And how that intersection can lead to really serious consequences, actual legal battles over free speech rights for people who aren't citizens but live among us.
Exactly. And that recent preliminary ruling in the Khalil case, it really underscores the willingness of courts sometimes to scrutinize the government's use of even these long-standing, broad legal powers when they seem to clash with fundamental rights like free speech, even for non-citizens.
So this deep dive really shows us a real-world example of how these debates over language, over definitions, they aren't just academic. They can become tools that impact people's lives, their legal status.
For sure. And it also reveals how these historical laws, things designed maybe decades ago to control perceived threats, like the McCarran-Walter Act, can be sort of dusted off and applied in new ways in modern political contexts.
It really brings that historical tension right into the present day.
It does.
So here's something to think about. In a country that at its core values free expression, how do we navigate this incredibly tricky line, the line between protecting national interests, including foreign policy, and safeguarding the rights, including the right to speak politically of everyone living here, whether they're a citizen or not? And what does the reappearance of laws like McCarran-Walter in these specific cases tell us about how persistent these tensions are, and maybe the constant need to stay vigilant about civil liberties? Leaves you with a lot to chew on.